Good evening, all. Good evening to welcome to another edition to the lecture of the workshop. We're so happy G Arunima here to deliver her lecture. The session today is moderated by Dr. Susan Thomas, faculty member of the department. Susan, over to you to moderate the session. Thank you.
Thank you, Shiva. Good afternoon and a warm welcome to all to the 13th edition of the webinar series organized by the Department of History, Sree Sankaracharya University of Sanskrit, in association with the Kerala Council of Historical Research. Before I hand over the platform to Professor G Arunima, who will be talking to us today on the topic, the past and presence of law, reading the legal archive, let me call upon Amrita, our MPhil student, for a formal welcome. Over to you, Amrita.
Thank you, Miss. Good evening to all. Today is the 13th lecture of International Workshop on Sensing the Past, Thematic Departure and Archival Searches, jointly organized by Department of History, University of Sanskrit, and Kerala Council for Historical Research. We have eminent scholar Dr. G Arunima today, who is professor at the Central University for Women's Studies, Jawaharlal Nehru University. She has researched and published widely on both the historical and contemporary context of India, focusing particularly on cultural, visual, and material texts and rethinking the politics of contemporary. Thematically, her areas of historical research interest can be divided into the study of family and kinship. Both historically and theoretically, different aspects of aesthetics and modernities, visual culture and theory, and religion and faith practice. Currently, she is completing a monograph on the cultural history of Kerala, bringing together the question of the gender, caste, and power and way of rethinking the social. She is the author of There Comes Pa, the colonialism and the transformation of metalling in Kerala, Malabar 1850 and 1914. And she is recently translated by Rosie Thomas' biography of her husband, the iconic playwright of C.J. Thomas from Malayalam to English, and edited volume on love and revolution in the 20th century colonial and post-colonial world. Perspectives from South Asia and Southern Africa is forthcoming of Palgrave. I welcome the distinguished speaker of the day, Professor Dr. G. Arunima, to deliver the lecture on the past and present of the law, reading, and legal archives. And also welcome all the participants to the lecture and activities to be participated in the section. Have a wonderful day. Thank you.
Thank you, Amrita. Before I invite Professor Arunima, let me remind the participants to kindly mute your microphones and switch off your video during the lecture. Those of you who have joined us through your phone, please see to it that you do not touch it to cause the presentation mode to be turned on. The participants may please type in your questions in the chat box that will be then read out to Arunima to be answered after her lecture. Today's attendance link will be made available in the chat box later, and in case you are unable to access it, please request for it in the chat box. Thank you. Professor Arunima, the floor is all yours now.
Thank you, Susan. Thank you very much. I wish to thank the History Department and especially Shiba, who has kindly invited me to be a part of what I think is a very important set of discussions that have been ongoing on sensing the past and ways by which many of us who are professional historians, but many others as well, to think about the archives. And I'm sure speakers before me have reflected on this question from different angles and posed different kinds of questions to this. So I am not going to spend too much time on that, because through the course of what I want to place here before you, I want to actually enter various kinds of dimensions of the archive itself. So I will actually stick to the broad brief that was given to us by Shiba, because I think that it is actually quite an interesting exercise to reflect on the historian's craft from time to time. And as those of you who are particularly students of history, you would have been exposed to many such discussions, I'm sure, in your classrooms, and large numbers of ways of, reading the past, utilizing a variety of sources, and bringing very disparate kinds of materials together. So it's not that any of this is going to be entirely unfamiliar to you, but I think what is actually interesting when one does it with one's own practice, and that's what I'm going to do, which is actually reflect from aspects of my own research for the most part. It is an interesting question to think about the choices that one made or the departures that one made and the manners in which the reconstitution of what one finds, the reconceptualization of what one finds, the way in which one actually recasts that becomes quite an interesting exercise. So I think it is worth spending time reflecting on this. And I am going to sort of hesitate a little before using the term methodology, of which I'm a little suspicious. I'm one of those skeptics, because I actually do think that there's a lot which is unmethodical. It's reflective, but it's unmethodical. And I'm not so sure that one should be, as practitioners of thought, because, without thought, one can't actually write anything. I don't think one should fuss too much, as it were. As the younger generation say, I'm not too fussed about it. All right, then. So prior to, what I have done is I have divided this up into what I call 5 different moments. And these are moments from different parts of the research that I've been doing since the 80s, starting with the earliest, which was my doctoral research on matrilineal kinship amongst the Nayars in Kerala, particularly Malabar. But, it moves away from there, and it engages a range of other kinds of sites and contexts. And what I want to think with you is really how one makes sense of these, the ways in which different kinds of forms of the law, and sometimes, and one of the kinds of instances I'm actually going to speak about is of illegality, how we make sense of that and where we access that from. Would it even be correct to call it the legal archive? Because I think that's too neat a term to actually encompass something that's actually pretty vast and varied and has different kinds of, in the absence of a better word, different kinds of morphologies. So I think it's worth thinking about, what one, how one makes sense of what one finds. So in 1999, just before I begin my own sets of reflections, I was reminded of a book that I had read a long time ago, Carlo Ginsberg's The Judge and the Historian, when Shiva asked me whether I would speak on the legal archive. And the first thing that came to my mind was this book, which was published in English, at least, originally written in Italian, in 1999. So it's easily 2 decades old. And what's actually interesting about this text, and a lot of the kinds of sort of pastimes of scholars like Ginsberg and others, E.P. Thompson comes to mind, particularly Whigs and Hunters, Albion's Fatal Tree and others, people who have actually thought with the law, historians who thought with the law. What one is struck by on the first viewing of what one is actually looking at is the ways in which both law and history seem to be sort of sharing certain kinds of commonalities. And these commonalities have to do with truth-seeking aspects of this, which is to say, there appears to be, and I specifically want to actually lay an accent on the appearing to be, because it isn't exactly like that, and I will go on to say why. There is a way in which historians and those within the legal profession are apparently engaging this question of truth. Now, for those people, so those who work within the law will speak about a variety of such procedures, for example, be it evidence or testimony, or whether something is verifiable, can something actually act as proof? And we find that even historians use this kind of terminology a lot. I mean, this business about, how do we look at the source? Is the source an evidence for something, right? Or is the source something else altogether? Is it a text that we need to actually think about completely differently? Is there something, what shall we say, a little restricting about merely engaging the evidentiary aspect of the source itself? And, let's keep that alongside on a side to think with as we go along this discussion. Now, in Ginsberg's case, the reason why he wrote this book was because of a very important trial that happened. And one of the people who was on trial was a close friend of his, right? And he had been convicted, accused, and then subsequently convicted for having engineered the murder of a very relevant political figure, and his friend refused to actually sort of contest this charge and sort of take it up to a higher court. And there's a complicated story behind that. And Ginsberg was very certain that this wasn't the case. And he set about to write this book. He was provoked into writing this book, shall we say, because of the ways in which the judiciary actually perverted the truth, right? So the kind of standard site from where we think truth production happens seemed to be precisely the same place where, despite using all these kinds of devices, these truth-producing devices, there were ways in which the truth was entirely subverted. So this is what provoked him. But when I began to think with this, I was actually, and this is, on a slightly lighter side, as I was thinking about, how to put this talk together, I was thinking, how does one actually describe the historian? Is the historian somebody who's, detective, an investigator, or should we use far more labor-friendly kinds of analogies like being a seamstress or a cobbler, somebody who stitches something together, pieces from the past, right? And I actually like that a lot. Even though what we produce at the end is a perfect artifact, or we think it is at least, how do we think about our going back to the past constantly? Are we time travelers? Are we storytellers like Scheherazade and so on? I mean, how do we actually think about ourselves? And I think in that exercise of thinking about what we are doing, we can actually begin to think not only about the past, because historians are not just interested in time and the past purely in terms of what today, again, to use a sort of more commonly used term these days, a timeline, right? We are not only interested in something like that, we are actually interested in what do we do with what we find, right? How do we actually conceptualize it? How do we help it to imagine something? How do we go about writing it up? Because as we know, the minute we start writing something up, it begins to acquire a life of its own, right? So it doesn't matter that you might have gone and excavated something from the past, but when you begin to actually recast it in the present in the form of a written text, it acquires a certain kind of life. So there are very exciting kinds of things that seem to be happening between that which we recover, that which we find fragments of, that which we get a trace of, that which we get a hint of or a whiff of, and then how we actually go about putting it all together in the story that we actually tell. Right? So in some ways, this exercise today with you is trying to see the ways in which, my own research has intersected with different aspects of the law. Right? So the first moment then, in my 5 moments, the first moment And this was my first encounter with the law. Now, the interesting part of that was, and I always like to tell particularly students the story, because my encounter with the law was entirely serendipitous, right? It just happened by chance. I wanted to write a thesis on the family. I was looking particularly at matrilineal kinship. I was thinking about matrilineal kinship amongst the Nair. And I had spent easily a year or more in the archive. And here I'm speaking about the official archive, which is, I was then using the, in those days, what's now we have 3 different regional archives, one which is in Trivandrum, the other is in Ernakulam, the third is in Kozhikode, in Kerala, that is. But in those days, because the Malabar presidency had been under, the Malabar district had been under Madras presidency, the Kozhikode Regional Archive was actually within the Madras archive. Later, it got bifurcated. But, there was lots of, particularly documents, revenue-related documents, but many other things as well that were public, and a bunch of other things that you could find in the Kozhikode Regional Archives. And I had spent a substantial part of a year actually sitting there, smelling the dust. There's a beautiful book by Carolyn Steedman called Dust, and it's really worth reading, those of you who like to read about the archive and the archival practice of the historian and so on and so forth. And you will know, I want to actually one day write a book about crumble, which is to say the documents I've looked at and nobody will ever see again because those have crumbled. So there is a way in which the historian is also an annihilator of the past. And I hope nobody in power hears me saying this, because I'll be charged with some impossible legal sort of penalty, I'm sure, for having stated that things that I was reading actually crumbled in my hands. But jokes apart, I think the interesting thing was having spent 6 or 7 or 8 months in Kozhikode Regional Archives primarily, but also what in those days was called the cellar records, which was actually housed in the Secretariat building in Trivandrum. And a lot of this has now moved to the main archive itself. I found that I knew everything about how much, the cost of pepper or coconut or rice and a whole bunch of other things were. I knew about, decennial sort of prices of produce and how these were sold and where these were sent and who was actually engaged in this exercise. The who part of it, of course, was far more limited, but for the most part, I had economic history at my fingertips in very abstract terms. I knew about 4 or 5 decades of an extraordinary history of the way in which the economics of the kinds of agricultural produce that was central to the economy of Malabar, how that actually functioned. But I had no idea about the family at all. I had no sense in which kinship worked. I had no sense in which matrilineal was given shape. There was absolutely nothing in any of this about the family. And I was entirely and completely depressed at that point, even though I had produced a 100-page long piece of writing on these moving averages and the economy and so on and so forth. And I actually think that that was solid research. It came into my thesis in some ways. And it really, I would at some point really like to go back and think with that material again. And so one day, as I was sitting in one of the libraries, and as one does in libraries, and that's why libraries are so important, and in a world when we connect so seamlessly and easily with each other using this kind of technology, which is quite marvelous, I must say, even though I can't see your faces, it is an interesting and important fact that we do need to keep our libraries alive. And as I was sitting in this library and I turned in a kind of despondent way towards the window and looked outside and then got up to stretch my legs, I suddenly looked at one of the shelves and a book was literally crying out to me saying, "Pull me out." And that was this book written by Lewis Moore called Malabar Law and Custom. Right? This is a book which was published in 1900. And the discovery, this entirely serendipitous, this entirely chance discovery of this book changed the course of my research entirely. Right? Now, what this book did was, so this was written actually by a person who was a judge in the Madras High Court, who knew the Malabar material very well, who had himself been involved in adjudication and so on and so forth. And it was full of details of judgments and of what at least he saw as critical judgments in relation to the family, in relation to, inheritance and particularly property-related questions, in relation to the ways in which, who would actually succeed whom. So questions about succession and descent and, who inherited what, and could somebody actually partition the family, get land, and so on and so on. Many, many different kinds of cases. And, for those of you who might have had a chance to glance at that book, the early book, you would know that a lot of that is based on precisely this kind of so-called evidence. Now, once I had found this, I then got a kind of toehold into how to think about this question. And it meant moving back and forth, as it were, back in time and forward. And tracking this kind of story of cases and using the story of cases and case law to actually begin to piece together a story about the family, right? Now, what one finds then, of course, and what I found to my great amazement and interest was that you had all kinds of judgments, from the late 18th century and early 19th century onwards, still, I must have looked at it easily 100 or 120 or 30 years of judgments. And these were there in law digests and in law reports and in different kinds of compendia that put together these cases, right? And in some ways, my thinking about the family was linked to the ways in which the logic of these cases worked. Right? Now, if one passed through this material, and I did parse very carefully through this material, and in this instance, what one must understand is that one is using the term archive in a very capacious sense, right? You're not any longer speaking only about the official archive. You're actually speaking about libraries, books. Now, a book is, of course, not an archive, but it can constitute a part of that archive, as it were. What I found was, and I think this would be true of most of us who have used this kind of material, and I'm thinking particularly about the extraordinary early work done by Lucy Carroll, who actually worked on, widow remarriage and so on and so forth. And, one of the things that you begin to understand when you work with this kind of material is that it's not just about telling the story of the family, or story of matrilineal, or story of kinship, and so on and so forth. You also need to understand why the law, as it were, looks or behaves in certain kinds of ways, right? Why is the law a certain kind at a certain time, right? Why are certain kinds of judgments being made in particular kinds of ways? Who is making them in those kinds of ways? What are they drawing upon? Why are they drawing upon those kinds of things, right? So there are bunches of things here that are actually very important, which is that we go behind the judgments. We need to tell the prehistory of that. Right? Now, some of this is, of course, particularly for those of you who are attentive to, what's happening in the domain of the law in the contemporary period. This is pretty commonsensical. Right? One of the things that we know, the simplest kind of example to be given is that cases are almost always delayed. Oliver Mendelssohn has done excellent work on this. And, one of the I know this for a fact myself because I've actually looked at cases from a single family which have actually dragged on for more than 3 or 4 decades. Right? So several generations sometimes who are fighting some case, and people who might have originally filed those cases might be dead and gone. Right? So there is something to be thought about what it means when cases are delayed in this way, and in the simplest instance, of course, for those people, and depending on the kind of case you're fighting, but in all cases, you are looking for some kind of remedy, right? You're looking for some kind of justice. This is going to be hugely delayed. Right? So there are severe consequences, as it were, to that delay. But the minute one begins to engage the question of delay itself, one begins to be speaking not just about formal properties of the law, but you're also speaking about other kinds of affective and other dimensions of the law, right? So, and we need to be attentive to that. Again, from the contemporary moment, we know, particularly in the case of criminal cases and so on, particularly political cases that are very big, witnesses become hostile, judges are biased, right? Advocates are extremely expensive. And again, another instance that I was thinking about, when I was thinking of, what the contemporary tells us, we know that most poor people benefit enormously if there are lawyers who will work for them pro bono, who will work free of cost, because litigation is extremely expensive. And one of the things that I had discovered, not through law reports and so on and so forth, but through actually the government's kind of taking stock of these things, is that by the late 19th century, Malabar was the most litigious district in the Madras presidency. Right? And now what does that actually mean? It means that those with money, and much of the early work that I was doing was actually looking at people who could afford to fight those kinds of cases, right? So the land and family story is always, it's not just that it's about Nair matrilineal, it's about those Nairs who were part of large households and who had the money to litigate. So the minute one begins to think with the law, one needs to actually be open to thinking about the kinds of ramifications that there are, right? It's not just about what will it tell us about the family and what does this judgment say and so on. And yet another kind of dimension to this is to do with the past of what we understand as family law today. Today we call it personal laws and so on and so forth. Now, when you begin to work with legal material, what you begin to understand, of course, is that much of the kinds of framing devices, the broad kinds of ways in which there are codes, law codes, shall we say, or laws governing groups of people. These were, especially and I'm speaking only about the colonial period, these were actually co-produced, as it were, by considerations of the state's interests and imperatives, particularly of administering regions and so on. And the 18th century law codes are a very good example of this. And perhaps, one way to teach something like this is actually to sit and read codes together. And what's actually quite fascinating about the 18th century and the latter half of the 18th century is that it's not just the formal bigger sort of framing codes and so on, but it's also what we call in Malayalam Vyavaharamalas, what is supposed to be closer to people's practice and so on and so forth. Even those were produced as part of colonial states' sort of imperatives. There was an entire sort of cottage industry that was producing Vyavaharamalas in that period, and they all, as is the want, as we know, if those of you, and I'm sure large numbers of you follow contemporary politics, and you will find that There are people who will tell you that, oh, no, this has happened in India. The phrase that's used is from time immemorial, right? Now, what does that even mean? The time immemorial is a very, very slick device, as it were. And what we find, of course, is that the Vyavaharamala writers were quite clever in that sense. And they would say, oh, no, these customs have been there from the beginning of time itself. So there's something quite interesting there. We find with the early courts being set up, and by the late 19th century, you find that the sort of appellate structure, the appeal structure, as it were, there were 11 kinds of stages through which you could go from your little village sort of arbitration place to all the way to sort of presidency level high courts and so on. So there's an entire story of case law, which is to say, you can have any kind of legislation, you can have any kind of code, you can have any kind of formal law, but it will always be tested in the courts. And that is what makes law actually very interesting, because it often undoes the principles that are actually laid down in codes, and it's worth thinking with that, and the appellate structure. Now, what's of course important when one thinks about the appellate structure is that when you're lower down, and particularly in the colonial period, what you will find is that the lower down you are, the appellate structure, you would find Indians who, and in the village level or even the district level in Kerala, you would find Malayalis who would be there. But the lower courts certainly had more Indians within it, and usually they were more sympathetic, they were more open to listening to practice and, the sort of myriad kinds of customs that people would come and cite and so on and so forth. So it's quite fascinating to look at lower court cases, whatever gets, particularly for the early part of the 19th century, a lot of it is just sort of summarized. But even the summaries are kind of fun to read because you get a sense of how these are different from the ways in which they change by the time they reach the higher courts. Having said that, if one is to go back to the question of the kinds of imperatives, state imperatives, imperatives of administration, case law traditions, appellate structures, different kinds of, the racial distinction of judges who were part of this structure itself, you begin to find that the law cannot be understood as something that is completely abstracted from the way in which society works, right? And one of the early, and I think best, even today, one of the best expositions of the kinds of relationships that one can begin to find when one works with colonial law is the book written by Duncan Derrett, J.D.M. Derrett, called Religion, Law and State in India, right? And what that book did, and for many of us, again, who work with this kind of material, it was very important because what that book did was to actually track back to English jurisprudence and a common law tradition, and to make one understand why, let's say, Anglo-Indian law had the kind of character that it did. Right? Which is to say that, when you begin to actually look at the substantive detail of many of these codes or the ways in which case law traditions emerged, and there are many, many dimensions to it, and paucity of time doesn't let me go into the sort of fun, nitty-gritty details of this. What you begin to find, of course, is that it is the focus on, let me just give you one example, right? Because the English came out of a tradition where they looked at religious law, right? Ecclesiastical law, to actually think about the ways in which they understood the functioning of law itself in terms of its formal properties. When they came to India and they were thinking about, and why were they busy devising these codes? Because they wanted to administer with ease, right? I mean, that's the simple answer, and sometimes it's just good to go with those. What we find is that it has elements of anglicization and it has elements of Brahmanization. Right? And this is not at all surprising, because when you actually look at early moments of lawmaking, whom were these people talking to? They were talking to Brahmin Pandits, and amongst the Muslims, they were talking to the Maulavis, and so on and so forth. So all the queries about people's lives, right, about the laws governing people's lives, were all asked to people who they saw as the ones who really understood religion. And they saw religion as the kind of basis for governing the lives and customs of people. Right? So there are very fascinating kinds of fallouts of this kind of an entry point, as it were. And so much so that, when you begin to look at anything to do with marriage or inheritance or descent or rights over property and so on and so forth, or, who would administer it, how much would a woman get, or would she inherit or not? I mean, just to give you one little example, all this was actually framed in particular ways because the answers to questions that were asked were given by certain groups of people and not others to begin with. But the questions themselves are asked in particular ways because the question askers came from a context where they thought that that's the way in which customs were actually produced. So there is something quite fascinating about the ways in which you can begin to see not just religious distinction of, so Anglo-Indian law very early on itself had the character of Anglo-Hindu and Anglo-Mohammedan, as they called it, laws. But also, it's not just that it was every ordinary Hindu or Muslim on the road that they asked. They actually asked the priests. So there is a way in which there is a kind of hierarchy of opinion, as it were, that is produced about, who has the right to actually speak legitimately about custom and what can actually legitimately enter the domain of law itself. Right? And I think that's something that we need to think about because, that's the prehistory, as it were, to the making of many kinds of systems, which then we understand as, patriarchy or the hierarchies of caste or the ways in which, different religious groups were seen to sort of function differently. Now in the Kerala case, what is, of course, for those of us who have worked with questions about kinship, and I'm very delighted that there is a younger generation of scholar who's interested in working with matrimony amongst Muslims. I had done a little bit of work myself some years ago, which I haven't published, but I find that actually a very important area. But in the 19th century, it's really worth remembering that at least 50% of Malayalis, if we can use the more modern term for the 19th century, were actually matrilineal, right? One way or the other. So there were Christians who were matrilineal, there were Namboodiris who were matrilineal, and so on and so forth. So it's a fascinating kind of domain, as it were. And it's interesting how all that gets recast and cleaned out and streamlined in particular sorts of ways. And perhaps we can talk about that later, but this is just to give you an instance. Now, just to sort of sum up this, the work on this material that I had actually done, one last interesting example that I want to give you, which is by the latter half of the 19th century, you find that especially the presidency level judges would use sort of precedents from other parts. So you could have a case on, say, Kerala property or whatever it is, Malabar property being adjudicated, but the precedent would come from Bengal presidency. So, this is what one means by the ways in which there's a certain kind of administrative legal unification that's taking place, and even prior to the kinds of ways in which you have the birthing of the nation in 1947, etc., or even the kind of launching of the idea of an Indian National Congress, as it were, in 1885, much before that, the colonial state itself is carving out a certain kind of sort of unifying principles whereby you can begin to see groups of people who had very diverse practices from one another, very different customs and so on and so forth, being brought together via these different kinds of devices, the uses of these devices and different kinds of protocols. So I think there's something about the need to not just look at what the source itself has, but also have critical reading practices that things simultaneously about the making of the laws, the making of the codes, the making of legal practice itself. Right? Without that, we won't have much of a sense of what's actually happening. Now, the second moment that I want to look at is from the story that begins to then change if one is not looking at legal judgments and the. I do pass this from a long case record, but it comes from the papers of a particular family, whose papers I got very luckily, called the Icheratu. They're from Koilandi. And they were busy burning it, unfortunately, all these papers. And I sat there in this kind of aghast way with my jaw falling open. I said, no, please give them to me. And so I packed up a little suitcase and brought them away and spent, months looking at the kind of messy domain of how their ancestors had fought with each other. Now, this one particular case is from the Icheratu Tarwad itself. And it's a fight between two brothers, right? Gopalan and Gannaru. But that's not the significant part of the story for me. Now, what is actually interesting about this case is that when you actually look at the list of defendants, the people who were cited as those who are implicated in this case, you find a variety of different castes, right? You find Tiyas, you find Chalyas, right? And you find that some of the Tiyas are cultivators, some of them are moneylenders, some of them are traders, some have taken mortgage, others are cultivating the land, and so on and so forth. Right? So just to give you a flavor of this, right? One of the cultivators is somebody called Kannadan. He's a Tiya. And for the non-Malayalis here, in today's sort of caste hierarchy, they would be the top of the other backward castes. And there's Govindan, who's a Chalya, again, OBC. Now, both of them had mortgaged land, right? But once they had mortgaged it, they had subleased it. Right? Now, one of the things to understand about, and those of us who work with land and land-related matters, particularly in this country, what we need to understand is that it's not just property titles. It doesn't matter if I'm a landowner and I have a property title, that is a formal title. The rest of what actually happens in the lived life of cultivation, it works in these kinds of ways. These are leased and subleased, and different people have rights over them for not just their own lifetime, but over generations. So one of the women who actually cultivated it was a Tiya woman called Kurcha. She had 5 children. Now, when she dies, she had managed to sign the contract in such a way that her children managed to divide up that land amongst themselves, right? Now, they further mortgaged it to another Chalya because they needed money. That's how the actual economies of land and cultivation work, right? And over a period of time, because they prospered, they managed to buy off the share from this chap who had actually lent them money. But at the same time, that guy was pretty smart, and he had given, he had made sure that his younger brother would actually inherit his rights. Right? So that family also continues in the story. So the point that I want to make here is this, that you can find Tiyas who are creditors and cultivators. Right? So you can't simply have an easy kind of well-tiered, neat little hierarchy, caste works like this, then cultivation works like this. It doesn't. Actually, when you begin to, and I would strongly advise young people who are studying land and tenure and caste to actually put these things together. And this we actually do get from the cases. And what I'm doing here is looking at the case law material to actually read off about caste and professions and the kinds of ways in which these fragmented leases and subleases actually tell you a lot about the ways, not just about rights to land, but also the ways in which property and money actually work within certain kinds of economic contexts. Right? So just simple terms like landlord and tenant and cultivator are actually quite what shall we say, restricted, and they do not give us the flavor of how these relationships actually work out. And the figure that I find fascinating in this, of course, is Kurucha, the cultivator, who was smart enough to have signed her basic contract in such a way that her children would inherit. So, when we also have this idea about patriarchy and, there are all these sort of wicked men who control everything and the women simply are, voiceless and, incapable of taking any kinds of decisions. In fact, one of the most fascinating kinds of things that we do find from this broad area that one can call the legal archive is that these figures and actors work in all manners of different ways. Now, the third moment that I want to look at flips this back again. And here I'm actually looking at a deed, and this is all more recent work that I've been doing. This is actually the sale of slaves. And, we know that, Sanal Mohan's phenomenal work on slavery in Kerala, of course, looks at a wide variety of different issues in relation to slavery. One part of which, of course, is to do with property, but of course, his interests exceed that, and he looks at the ways in which there are sort of redemptive kinds of stories through theology. But an earlier work by K. Sharadamani actually looks at the kind of property dimensions of slavery a little bit more, because she was interested at that stage when she was doing that work on the slavery abolition question and whether indeed slavery was actually abolished or not. Now, what I found quite fascinating, and I will tell this in two different ways, I was looking at these deeds because I was looking at the property form, right? So most often when we speak about property in relation to especially women's rights and so on and so forth, land rights, we are talking about land, right? Now, what happens when you look at property as a human being, right? What is it that we need to think about when we are talking about slave as property? And this particular one is of the sale of a slave called Chiruda. Chiruda in Pudakalli. Anyway, since there are many non-Malayalis here, I will leave the actual sort of language of this is from 1844, it's from Kottayam district in present-day central Kerala. Now, it seems that this form of sale appears to have had two steps, right? The first is an oral understanding between different witnesses. Right? So there are four people who get together, they witness the sale, they have a kind of oral agreement, as it were. The next stage is when this is actually recorded on palm leaf documents and so on, right? The Ola. Now, as we know, most of us, again, who work with this kind of material, whether it is land or whether it is a slave as property, but even other kinds of dimensions, even if we don't talk about sales and so on, we know that writing has a certain kind of power. Right? Writing has, and that form of inscription actually is, in the context of slavery, is far more debilitating for the slave than, let us say, an oral agreement would have been. Now, one or two of the kinds of dimensions of this really struck me a lot, partly because my earlier work had been on matrilineal, is that the term that's used is amma marga, matrilineally. She was being sold matrilineally. So it's Tirudha and her son Jodi who were being sold. Now, what is, of course, significant here is that unlike the landed Nair Tarawad woman, when we speak about her rights and so on and so forth, we are talking about her rights to property, her right to authority, to be a Karnavastri, Karnavati, to sell, not sell, lord it over her siblings, etc., etc. Now, when you talk about the enslaved woman and you talk about amma margam or matrilineal, you're talking about exactly the opposite. It is actually the loss of everything. Right? For her, it is the ownership that the buyer has or the seller has over her sexuality, over her labor, over her reproductive rights, whether it's her children or the kind of agricultural production that he does. And when you actually look at the precise wording of what is allowed to the person who becomes the contract tells you what kinds of rights are being handed over. What it actually says is that the owner now has complete rights that can extend to chaining and even killing the slave, right? Kollinum kolekkum, right? Kettum pootum. So in other words, what we need to understand is that, not only is her sexuality, her labor power being expropriated, her children being handed over matrilineally, as it were, if she, for whatever reason, either she displeases the owner or the owner has had enough of her, she can just be annihilated. Right? She can just be killed. Right? So this is the only form where you are not just leasing and mortgaging or selling property, you are actually annihilating property. And that is the kind of the extermination of the human as property is the kind of extent of the right. So it's not just ownership, it's the right to kill. Right? And I think there's something extremely chilling about this, which I think we do need to think about. So it's not the end of property in that sense. It is actually the increase of power of the landowner, of the slave owner. Right? Now, I want to, towards the latter half, I have not too much time, but I want to talk about two more moments, one of which links to what I've been speaking about just now in relation to slavery, which I call the moment of illegality. Right? Now, this I get from two different, and there are two examples I want to give you. One is, so as perhaps some of you at least know, the English East India Company passed the slavery abolition, the government of India, as it were at that point, passed the Slavery Abolition Act in 1843. Right? And, excuse me, and this was later in Travancore and Kochi in 1854 and 1872, and that's not material, but I just thought that since we are speaking about this. Now, the reason I'm mentioning this date is that this particular extract that I have is about Connolly, who was the Malabar collector. Right? So despite the fact that slavery had been abolished formally by the government of India, and any number of, if you look at different kinds of sources on slavery in this period and slavery abolition, you will find the English sounding very self-righteous and speaking about how it's their, the morality of their government that had actually abolished something as inhuman and aberrant as slavery. Look at the Dutch and look at the Portuguese and look at how they exploit, people and so on, the slaves, and they believe in slavery. But what you actually find in this extract is Connolly promising, and he proclaimed that the government will not, and I am quoting from him, will not order a slave who is in the employ of an individual to forsake him and go to the service of another claimant, nor will the government interfere with the slave's inclination as to where he wishes to work, as though the slave has any inclination. But he also ensured the slave owners that any person claiming a slave as janmam, karnam, or panaya, right? So as pure property, rental property, and so on and so forth, or mortgage, the right of such claim or claims will not be investigated into at any of the public offices or courts. Now, this is really fascinating, because here is this man saying all these things well after the company had actually abolished slavery, and he's ensuring the slave owners that, the collector was behind them, the slave owners would be protected, nobody would be prosecuted, they would make sure that their rights would continue. Now, this is something, we know this from Gyan Prakash's early work on bonded labor. We know that the kind of transition that actually happens in this country, and you can see this even today in many parts, that, large numbers of impoverished people who work invariably, Dalit castes, who work on land, work in different kinds of conditions of bondage, right? So you may not be formally a slave. Slavery abolition might have taken place in the country, but it doesn't mean that the kind of life that you live out is actually any different. In fact, in some senses, it's actually even worse, because, despite slavery abolition, there's nothing that has been done to make your life better or simpler. The second, and this comes from the revenue records and so on. So here is an example of illegality, as it were, so to do with the law, but on the other side, coming from the revenue records. So that's why I was saying that it's very difficult to actually speak about a sort of neatly available body of material as constituting the legal archive. The second is from the missionary archive. And this is, again, to do with caste and conversions and so on. And this instance that I want to give you comes from, letters that were written by a very important missionary in Travancore called Reverend John Cox. And between 55 and 57, he wrote off several impassioned letters to the government of Madras, saying that new converts were actually being, prosecuted and tortured and so on by functionaries. In fact, there was one Diwan called Krishna Rao who he identified, and he was actually writing 20 years after the fact, putting together petitions that he had got from the families of people who had been tortured, and in one instance, there was a Pulya convert who had been killed. Now, what is actually interesting about, he had been working in Travancore in the late 30s, and between then, so let's say about 15 to 17 years later, he obviously was keeping track of what was actually happening, and people actually reported to him about these things, and there are other ways in which this news filtered through to him. And this persecution that he's speaking about were, at one level, what is actually chilling to read when one looks at that is how modern this kind of violence is, right? We imagine that there are certain kinds of horrible excesses that happen now. There were people who had been picked up and incarcerated who, as part of torture, there were the torturers, the perpetrators, as it were, who were state officials and their lackeys and so on, who were, urinating into their mouths, and other than the usual beating up and breaking their limbs and so on and so forth. There were all forms of torture that were actually perpetrated on the bodies of these people. And he says, and again, I quote him here, but now oppressions and extortions of the grossest kind and tortures so severe that life is periled thereby are commonly practiced. The oppressed may be marked for deeper oppression. Temporary imprisonment be commuted into continued illegal incarceration, and assault become aggravated by torture. Now, if we are looking at what is happening in contemporary India, so much of this is so reminiscent of what is actually happening, where you pick up people and throw them into jail, and then there's languish there. And in the case, we know this, as most of you would know, when recently Father Stan Swami was picked up, one of the things that came back into news was the large numbers, and in the last 2 years, one of the discussions that's happened is how many Adivasi youth have been thrown into jails and have been languishing there. And one of the kinds of things that we know in this country is that if we actually look at the history of incarceration, you will find that those people who are politically and socially marginal in this country, particularly in terms of caste or community, Muslims and Dalits, and in this case, in terms of criminality, young men particularly, are the ones who are picked up most often. And there's quite a lot of writing on this. But the reason I'm mentioning this here is precisely because here you have from the mid-19th century, you have an early moment, at least for modern Kerala history, of state-inspired violence and torture and extortion and unpaid labor. And when people refuse to comply, they are thrown into jails and tortured more. So, there is a way in which the missionary archive, because these are all new converts whose stories we know, gives us an insight into the ways in which the other side of law functions. But it also tells us about what the relationships are with those communities who are socially marginal and who are entering religions which are sort of moving away from the sort of control, at least the direct control of Savarna Hindus. But at the same time, I must say, however dire this story is, I found the fact that there were family members who were writing these petitions. So there is also a counter to this coming. There is a kind of way in which people are beginning to learn new methods of protesting illegality. So wives of those being tortured are actually writing to say, I'm not saying that it's not a painful history that they lived through, but they at least produced a written form of protest, which has survived 150 years or more so that we can read it today. Now, the last moment that I want to talk about comes from, work that I've been doing on visuality in the contemporary. So it's what I call the archives of the contemporary political. And as some of you probably know, I have been working on particularly photography. And in this paper, I want to actually speak about that in this presentation. And I want to actually look at the way in which the relationship between visual law and truth works. Right? Now, again, perhaps this may be unfamiliar to those of you who are not aware of the kinds of discussions around photography. But one of the kinds of long-standing, what shall we say? It's almost sort of entered the domain of a truism that that the camera has truth testifying powers, right? Because it's a mechanical device, there's no human interference. So if I take a photograph, then clearly what I'm showing you is something that actually happened. And we see this again and again. There are all manners of new kinds of photographic archives that are actually produced. Social media sites like Instagram, particularly, but also Facebook are good examples of the way in which people's own photographic archives are actually produced, and people produce themselves. There's a kind of self-performance, as it were, a self-fashioning through photography. But anyway, I don't want to get sidetracked into that. But there is something about the camera and the photographic image which is has been seen, and this is something that many philosophers have argued against. They're seen as possessing truth-testifying powers. Now, for the sake of this last bit of my argument, I just want to look at two kinds of examples from the context of university campuses. One is that of the use of CCTVs and CCTV footage, and the second is of the presence and absence of photographs and how that works into a very complicated kind of dynamic in relation to also thinking the contemporary political. Now, the thing about the CCTV, and I'm sure many of you yourselves have different kinds of experiences of the CCTV and perhaps even views about the CCTV. Now, I'm not a huge believer in the CCTV for any number of reasons, but just to give you a short history of the CCTV camera, I mean, it was first used in Britain and so on, and it came out of the interests of it came out of the interest of retail, primarily shopkeepers and others who began to use CCTV cameras to make sure that nobody stole from their shops. But it also sort of fed into a kind of logic of privatizing and securitizing public spaces. But more recently, what we find is that CCTV footage is apparently seen as being productive for checking political crime, right? And in Indian universities, certainly from 2015, I know the UGC had a long sort of directive on this. There has been a great push saying that university campuses need to have CCTV cameras. Initially, the argument was that this is for the safety of those who live there, students, faculty, non-teaching staff, etc., etc. And over a period of time, it became far more explicit, and they started saying that this is actually to check students' politics. And it's very interesting how this kind of student politics is being recast as a political crime. Now, historians and theorists of photography, people like Jonathan Finn, Alan Sikula, and others have all been speaking about, what they call the archival mode of bodily data collection, right? So repeat offenders. Yeah, and this, that the police album is a classic kind of site in which you can actually look at the ways in which certain kinds of images of the criminal are actually produced. And, we know this from cinema and so on. If you've seen enough of Hollywood films, you will know that their posters of the wanted criminal are put up, and the wanted criminal, of course, always looks a certain kind. So there's a kind of biotype of criminality, if you wish, which is supposed to emanate from the criminal body. And there is a way in which this is meant to sort of get reflected in the photographic image. And of course, once you have the photographic image, you can actually arrest the felon, you can arrest the criminal. Now, what kind of implication would something like this have for the way in which increasingly campuses are being seen as criminal spaces? Right? And we know this, protests on many campuses, certainly the campus on which I teach and have spent a large part of my recent working life. And also I was a student there very early on in a very different time. But also other campuses, so not just JNU, but also AMU, HCU, Allahabad University, any number of university campuses are increasingly being seen as crime sites, as it were, right? Because of protests and so on. And one part of this, and we see that with the kind of national educational policy and the kind of shift towards privatization, one of the kinds of implications of that is to actually produce the ideal student subject. Now, who is the ideal student subject? The docile subject, somebody who's a non-protesting, obedient student who will keep studying. Now, what we begin to see when protests gets criminalized in this kind, and in the JNU instance, we also had the administration going to court to say that there's, to get a high court order to say that protests could not take place in certain kinds of spaces of the campus, right? So the campus is getting marked in sort of ways as, crime-free zones, because protest is the crime that we are engaged in. Now, when we then tie this up with the ways in which there is a greater and greater push for CCTV footage and CCTV cameras being put on in different places, and there was a hilarious moment on my campus, at least at one point, where there was no, as is the want there quite a lot, there was no official notification about where the different places were where CCTV cameras were going to be put up. But we all knew where they were coming up. And mostly these were places where either faculty or students congregated, or as much of this was happening post-2016, so where protests happened. So, we would take to waving to the CCTV camera so that at least there should be some footage of us waving to them. But, again, just aside, the more serious problem with CCTV footage, because I've been researching this for a while, is that there is actually in the country, until now, there is no entirely well worked out set of laws on when electronic evidence can be used, which electronic evidence is actually permissible. There are no clear laws which say that CCTV footage can actually be used as evidence. And, in some cases, there are ways in which the Evidence Act is being reworked, but you don't have that in the case of CCTVs, right? So if that is indeed the case, and the second, and that's a more interesting mechanical problem, I mean, that's a sort of, thing about the device itself. Much of the devices that are used, because as some of you know, you have, this is an entire set of things that are wired together. There's a camera, there's a monitor, and, there's a recording device, right? Now, much of these recorders can't keep too much footage in it. So it will keep recording over old material that's actually present. Right? There, a few years back, 2-3 years back, there was a case that came up, and the Chandigarh police was asked, why aren't you using your CCTV footage? And they said, well, we can't, because our recorder can store material only for 9 days. So there you go. It's entirely useless. But what does the CCTV camera actually do? It makes you feel that somebody is watching you. You're put under surveillance, right? Even though the footage itself may not translate too much, you are made aware of the fact that someone has the right to surveil you. Right? And I think that's something that we might want to think about. Now, the second part of this, I want to link with two other kinds of things, which is the disappearance of a very young new student to JNU campus, Najib. Most of you would know about Najib's case. The instance of his disappearance, as it were, or his being disappeared, happened in October 2016. And the other case that I want to read alongside with that is the presence, as it were, of Muhammad Ali Jinnah's photograph, an old photo of Jinnah's, in the AMU Students' Union room. Now, prior to sort of speaking to that, I want to remind us of an early essay of Judith Butler's when she was looking at the Rodney King trial in the US, and she makes an argument which says that visibility is not just what is made visible, as it were. It's not just a question of a new technology, but how new technologies get inscribed within an existing racialized realm of the visible field. Now, Rodney King, as some of you know, was a Black man who was actually accused. So it's not a question of, what and who is seen, but how that what or who is actually co-produced by law, race, and technology. Now, if we move to the Najib case, what I want to use this insight into calling this a communalized field of visibility. Right? Now, in Najib's case, what is striking, of course, is that there until now, no one has come forward with any photographic material or any videographic material. Even if there was anything, probably students are too scared to present it, but perhaps there was none, which is a little surprising given the fact that people instantaneously take pictures and videos these days. But it's an interesting thing that there was none from that period. But also, having said that, I think what is worth remembering is that even if, let us say, there was something, because as many of you who probably know the beginnings of the Najib case, it begins with a kind of altercation between students belonging to the ABVP and Najib one night, and then his having disappeared the next day. Right? By the morning half, he had disappeared, and one has never seen him since. Now, in any case, let us say, even for the altercation, had there been something, we know nothing about what happened to him subsequent to that. So here is an instance where the absolute lack of interest on part of the university administration in conducting a proper inquiry and actually collecting non-visual evidence. There would have been enough and more students from the hostel who would have spoken. Our usual testimonies are oral testimonies, right? When you have a crime that happens, usually you have, if there's a robbery in my house, I'm not here. When the police come, they're not going to say, show us photographs. They're going to say, what happened? I'll say, well, my laptop was lying there. When I came home, the door was open and my laptop was missing, right? I tell them that. Now, there is none of the non-visual material, non-visual evidence being collected in Najib's case, as it were. But in the AMU and the Jinnah photographs case, what we find is that the presence of Jinnah's photograph in AMU Students' Union immediately makes them into criminals. So what are we looking at here if we use this question about the communalized realm of the visible field? What we find is that when the victim, and in this case Najib, when he is when you are looking at the way in which law, communal politics, and technology are co-producing Najib, who is a Muslim student, he's always already a non-victim. So no violence happened against him, and he has disappeared, but there is no official acknowledgement of his disappearance. So it's almost as if no violence can happen against a Muslim in this co-produced realm of a communal, political, visualized field, as it were. But in the case of the presence of the Jinnah photograph, and this is from the pre-partition period when he was a Students' Union president in AMU, the presence of that photograph. So in one case, you have absence of visual material, and you have this idea that, nothing has happened. And in the other, you have a presence. But because you have, the presence of the Jinnah photograph makes AMU, and for that, you have to read it as all Muslim, and all Muslim students are always already anti-national, because if you have the presence of Jinnah's photograph in AMU Students' Union room, it obviously means that, the only people who would actually keep it there are the anti-national Muslims. So you have in both instances, the absence and presence of photographic evidence gets implicated and gets sort of inscribed into the logic of a communalized legal field of visuality, as it were. So you have law, communal politics, and technology coming together to produce these kinds of effects, as it were. All right, I think I have exceeded my time by at least 15 minutes, so let me stop here now, and I look forward to your questions. Thank you so much.
Thank you, Amita, for that invigorating lecture. You had started off with your research in the legal archives from the 1980s, and you have gone down right into the present day when we have the CCTV and other technologies being used. You've shown us, in fact, how legal archives are not just things that you find in the legal discourse materials, but you can find it outside in other realms, in the revenue records and other things, and told us how you should think about property and things like that. Thank you so much for that lecture, Arunima. We have some questions in the chat box. Shall I read them out to you?
Yes. Yeah, that'll be simpler.
Yeah, this is from Jose Kuriakos. He's a PhD scholar at our department. His question is, historically, is there any past and present in law, especially in the sense of living law? How can a society like India assess the practices in law only in terms of written law in the archives that differ from reality that prevailed at that time?
Well, one of the exercises that I was trying to do here was to actually think about the ways in which there is a past to law. What I do want to, so to that extent, I think, much of what I was talking about did speak, I thought, quite directly to that. So it would be a little pointless in rehearsing that. But this question about, how do we think about reality and how do we think about law, right? And I think that's where case law material becomes very interesting. And let me give you an example, not from, I did give you examples from the past. The slave sale gives you one kind of sense of reality. I mean, much of what we know about reality is pieced together by passing through these different kinds of documents, whatever they might be. In this instance, I was actually looking at the material. But more than the slave sale, I mean, the Kuricha, the Dia cultivator, and the story around the different cultivators and, the Tias and the Chalias and the way in which they constitute a very significant part of early 20th century economy of North Malabar particularly, I thought was an interesting way of rethinking economic life. Right? I mean, the question that we need to ask is, what do we actually mean by life itself? Which aspects of life? Right? And much of what we know about life, even as we ourselves live it, is, after all, approximations and partial, isn't it? But if you actually look at a contemporary sort of legal, cases that are going on, and I'm sure you, like me and many of us who constantly follow sort of the important cases, I do at least, I find them quite fascinating. So if you actually look at what, say, very wonderful sort of contemporary websites like Live Law and Bar and Bench are doing, you will find that they track stories of the life of, say, people lived through that moment when they intersect with law, right? When they go to court, when they're produced in court. Right? It's a certain part, it's a certain glimpse of life. And that's as much as we are going to get with different kinds of things. Right? There is no totality of life in that sense that we can ever have access to. So the question is, how can we use a glimpse to abstract from? What can we do with that? And I think that becomes a more productive way, perhaps, to think about this, rather than thinking about it as, there's life and then there is law, or there's life and then there's photography, and then there's life and there's something else. It doesn't work like that. It's the old question about literature. Right?
Yeah.
There's life and then there's literature. But it doesn't. When there's a life within a novel, how do we actually make sense of that? It's the same kind of thing. There is a kind of set ways in which life gets inscribed into the history of litigants within the context of law. And I think case law is an excellent place to begin.
Yeah, the Tia case that you said was a very good one in that. Let me go on to the next question. This is also from one of our research scholars in the department, Avinash Simon. His question is, different sources mention that women's position of power varied from region to region, even when they belonged to the same caste in the set time period. in which all ways such power fluctuations made a difference in the family structure and the society as a whole?
Undoubtedly. I mean, you know, I think there is a kind of way in which, you know, we have a tendency, and usually it's a kind of shorthand to generalize on about either caste or gender or any of these things. We imagine that, you know, even if you belong to the same caste, everybody lives in the same ways, thinks in the same ways, their life trajectories are the same. Clearly, they are not. And that's why, you know, I mean, there are, of course, there's a sort of entire realm of new terminologies. But, you know, if we simply approach this using one vector, if we use a now very disused term, which I think it might be good to bring it back, which is class. If you actually look at where you are as within a sort of not a caste but a class hierarchy, you will find that people belonging to the same caste might actually belong to different classes. It's a very commonsensical argument, but it's worth doing. And the minute we begin to do that, we will begin to see, you know, what are the kinds of opportunities one might have. Right? If you came from a poor family, the opportunities you might have, let us say, to very simple things that you and I might take for granted, like education, may not even exist. And this is something that came to the fore very clearly when everybody started speaking about, you know, education in the period of the pandemic, and let us all, you know, transition to online education. And, you know, the first problem, and it is the problem that really does require great attention, you know, we need to give it great attention. And I know that friends who are teaching now constantly speak about it. It is the question about the complete access to digital, not just devices, but the internet. People live in, recently a friend was telling me that she has a student in her class who has to walk 15 to 20 kilometers to get to a place where he can actually have access to the internet itself. Clearly, the student does not even have a smartphone. So all the things that, you know, increasingly many of us are taking for granted are not available. Now, you may belong to the same caste, but if you come from an impoverished family, you would not have access to this. So if that is indeed the case, then I think that begs the question of, you know, what are starting point for talking about other things like, you know, positions of power and so on. Because many of the kinds of terms we use are for people who have basic livelihood questions taken care of. If you are completely impoverished, you are not going to even think about those kinds of things. You're going to think about survival. So how do we actually think about livelihood, survival, sustainability, and then talk about questions about power and powerlessness and so on? And there the question to be asked is, you know, just entering it, you know, just as much as speaking simply about class in an earlier period had its own kind of reductive possibilities. Similarly, I think, you know, if one is not attentive to the ways in which, you know, to use a term that has acquired greater circulation now, intersection, if we don't look at the ways in which these complicate one another, we won't be able to speak about many of the other kinds of questions that you're interested in. Let's say, you know, the kinds of positions of power different women from the same caste might have, etc., etc.
Yeah, the next question is from Dr. Roshan Parveen of the JMC. Hi, ma'am. Gathering the ideas from your talk, it is apparent that the judiciary system in India is loaded with personal background and society, and therefore not immune from business towards those underrepresented in the system. Other than those expecting justice from the system, living a false imperative. So in these trying times, is affirmative action possible to the rescue of the socially disadvantaged groups? How much idea of all Indian judicial service may serve this purpose?
I can't give you any meaningful answer to the All India Judicial Service at any rate. But I do think that, people who are, if you're speaking about the contemporary moment, it's a good time to actually think about precisely what you're asking, which is, what kinds of, who benefits from law. Now, let's flip this. What you say and what I was arguing are very dissimilar, and I don't disagree with that. But let's spit around and ask this from another point of view, which is one of the equally apparent kinds of things at this time are some extraordinary lawyers who double as activists, who double as political commentators, who are taking huge risks, who are actually fighting cases, whether it's on questions about, be it violence against girls or, the violence against Muslim women who've been raped in riots, or any number of questions of atrocity and so on, of different kinds. And that's one of the reasons why increasingly, and I feel this is going to actually sadly increase far more, there has been a far greater attention on these very brave lawyers who exist. And one of the most fascinating things that I have been tracking, or rather what I find fascinating in what I have been tracking, is how many lawyers there are in different parts of the country who sometimes for practically no charges at all are fighting these cases. Right? So we do also have that story. Right? Now, I don't know how to answer your judicial service question. Affirmative action? Absolutely, in everything. No question about that. We have to fight to make sure that that continues. Right? Indian reservations is the first step, and it's such an incomplete step. Right? The hostility to reservation, right? The attempt to undo it. I mean, we have to see every time we fight for this, we have to think about the kinds of action against certain kinds of very enabling parts of the Indian Constitution. So yes, absolutely, without a doubt. So we have to fight for affirmative action, but in terms of a unified judicial system, I don't know. It's not something I've thought about enough or at all, so I couldn't give you any meaningful response.
Okay, thank you. The next question is from Professor Sanal Mohan. Thank you, Professor Arunima, for your wonderful presentation. Could you please elaborate a little bit more on the significance of legal materials to think on history of emotions?
I see. So, Sarah, the thing is, thank you for that, and thank you for being here. The kind of work, for example, that I have done very recently, not my earlier work. If you'd asked me this more than a decade ago or a decade and a half ago, I would have said, impossible, we find nothing. But I do think that, as with other things, practices and of affect leave traces in different ways, right? So, for instance, if we let me try and think with you from two of the examples that I gave. One, the slave deed, and the other, what was the other one that I the the Reverend Cox story of the bits about torture of the new converts. Now, both of these are testifying to. So, for instance, the petitions that were written, which Reverend Cox uses, actually speaks of the pain suffered by the people who were picked up and tortured and thrown into. And I think that's a way in which one can actually begin to use that kind of material to, at least we begin to get a certain sort of angle into, the way in which a certain sort of beginning, shall we say, of a history of pain is getting written about. Similarly, if one looks at the kinds of terms that are used in the slave deed, I mean, I actually, when I read it, it was deeply depressing, in fact, to read the terms used in terms of, pullum pulim and so on and so forth, get them bootum. But each of these are actually testifying to certain kinds of ways in which the body is getting marked through violence. And if one uses that as the kind of site from which we can begin to think, like Foucault, then perhaps there is a way in which one can begin to extrapolate a form of, at least in terms of thinking about fear, thinking about wretchedness or helplessness. I think there are certain affective states that are being signaled by the ways in which the utilization of certain kinds of terminologies within the kinds of materials that we read, the kinds of provocations that they might have for us to think about, what you're asking. But more recently, for the volume that you and I are both part of, the Love and Revolution volume, my paper is on sedition, on the sedition law and 3 instances from that. And that's entirely based on using legal material. In the case histories, both starting with Gandhi and then subsequently Vinayak Sen and then JNU, and the use of sedition law in each of these, and the way in which, say, the idea of disaffection is first turned around by Gandhi, but at the same time, the idea of a kind of negative emotion that is signaled by the state in its utilization of sedition law, which says that you are non-patriotic, you are an anti-national, right? So there are certain kinds of expectations of love and loyalty that we are meant to have towards the nation via, the supposed sort of contract, our social contract, as it were, which is supposed to be violated in the kinds of acts that are called seditious. So in some ways, I think there is that history of emotions probably speaks about affective states which are not to do with the kinds of ways in which a lot of early writing on history of emotions work, which is the history of love and so on. But I find that, many of these other kinds of emotions, which are very integral to our existence, questions about fear, questions about mistrust, disaffection, hatred, anger, all of these leave traces other than pain itself. I hope that's a start.
Okay, and the next question is from Srinivasa Rao Yenda. On one hand, CCTV camera is being used as a tool to scare the rights-conscious citizen by the state. But on the other hand, criminal acts are videographed or photographed with the intention of creating fear amongst the Dalits, Muslims, and other minorities. Here, the criminals are producing evidence on their criminal act, but are not afraid of the law. what the law says about the videos produced by the criminals on their criminal act. Are they not perfect evidences? If so, why criminals display such audacity?
Okay, so that's an interesting question, and you may this paper which came earlier this year in I'm just trying to. It came in the contributor of the imaging of imaging technologies and so on, of which this CCTV material is one part of it. And one part of that paper is actually speaking to the question that you're asking, which I call the archive of resistance, right? Which is the counter visual that is produced by protesters, and it's not, of course, Dalits and Muslims alone. In fact, you find that they, I mean, it's actually protest sites that produce them, the different kinds of protest sites that produce them, and people who are comfortable with the use of, cameras are the ones who usually produce this counter archive. And there's an interesting question around what one does with photographic and videographic material being produced from political protest sites. How does one read that as opposed to, campuses like mine, for example, and I'm sure that's happening on most campuses. The CCTV, as I was saying to you, is really, it's more symbolic rather than actual, partly because of the difficulty of admissibility of that as evidence in court. But more than that, most of the devices can't really store for very long, right? So, and in many instances, the housing colony that I stay in, I'm sometimes very amused because they do have cameras stuck here and there. But it's always, I mean, I've always been curious about, how the entire CCTV system is set up. Because they don't seem to be linked to, I mean, unless there's a remote storage device, but I doubt if the colony has spent that kind of money or something like that. So, you have cameras mounted here and there. So they exist there. They seem to be, if there is a monitor, you might show up on it. How long it will be stored, we don't know. So in some senses, it's really, a lot of it is a kind of, an empty image, as it were. The image, I mean, the CCTV camera record, the image is always in negative, in the sense that unless it's produced, it's a non-image. Right? It's not like a photograph that I can show you. But so surveillance devices are used for a variety of different reasons. They signal, as I was saying, of course, in the context of political protest sites that that somebody else has the right to control and surveil. But of course, in more traditional kinds of forms of surveillance, these are housing colonies where you would have had, the old-fashioned chowkidar, the person who patrolled, who would have actually done some light policing at night to see. Middle classes have always been afraid of theft. So it's a theft protection. But the reverse, which is, why are protesters recording and why are they keeping this? And that actually, there's a lot of new writing on and thinking about this, about, what does one actually do? Why are people producing a counter archive? Okay? And one part of this, the Israeli visual theorist who's worked a lot on Palestinian material, she's on the pro-Palestinian activist of Israel, very important thinker called Ariel Azule, what she calls the civil contract of photography. Right? So it's what she's looking at is not really what a photograph means, but what a photograph does. So how can you use this? If a security person is shooting you, why would you shoot something else? Why would you shoot them shooting you? Now, we see this from so many different political sides. The classic and most difficult and poignant case in this country of course, is Kashmir at the moment. Right? Kashmiri photojournalists who are putting their life on the line, risking themselves, doing this kind of actual documentation. Right? So in a way, it does a wide variety of different things, including giving courage to people, saying that look at it, look, there is a Kashmiri photographer out there. So when you have security forces training guns at you, you have somebody training a camera. So there is a very interesting kind of sort of interplay, as it were, it seems to me, that's going on. And I think it's important to think about why that's actually done. I don't think there's any one answer, but I think the idea there being that this photograph or this image that's actually being produced, it becomes a kind of text of resistance. It can actually circulate because, photographs, unless they circulate, do not acquire a certain kind of life. And the minute they begin to circulate, they begin to produce other kinds of, say, communities around them. They mobilize in different ways. So that's a preliminary response to that. But thank you for that question.
Thank you, ma'am. This is the question from Rennie Thomas. Professor Arunima, thanks for a great lecture. I was wondering if we can also think about law beyond official legal documents that are available in the archives. Of course, you did mention that is possible. And look at laws, rules that guided the everyday life of people, especially thinking about the church registers and books in the context of Kerala that guided or controlled the everyday life of people and faith. What are the possibilities of considering them as an archival sources to study the histories of faith and discipline? As I remember Ginsberg saying in his lecture at JNU that there is nothing called good archives and bad archives. We only have archives.
Totally, I completely agree with that. And one of the things that I left out because that's entering a totally different realm altogether. As we know, and I'm glad you brought it up. The idea of divinity and legality, especially in the context of Christianity, is something that's very deeply intertwined. So it's not just the kinds of records maintained by parishes and so on, but the idea that a law is being laid down for conduct, and in terms of how one lives life, as it were, how one relates to one another, how one relates to God, how one is part of a community. And I think that the minute we begin to utilize that as an entry point, we are actually not just looking at an alternative site, we are actually positing an alternative to state-produced secular law. And that's where the interesting question, I think, it becomes complicated in the contemporary law. Because when you have two kinds of forms of legal possibility, as it were, and we see this coming and clashing, we see this constantly. So it's not merely a question of the sources of law, but what these laws signify. I think that becomes the more, the demand of us is that, and we see this particularly in the kinds of discussions around personal laws that happen constantly. The argument that is being produced is precisely this. So yes, undoubtedly, one has to take that on far more seriously, and it requires a set of discussions devoted just to that. But yes, I totally agree with you.
Yeah. Just to add to it, because it is these palm leaves of the churches that I have worked in. For Rennie Thomas's information, we have many of such palm leaf accounts of the older churches that have been digitized and all that. Ma'am, I think we have come to the end of the questions that are there in the chat box. There are many of them thanking you for your engaging and informative session. Thank you so much for those replies. And now I would like to hand over the mic to our research scholar Lukman Hakim who would propose the formal vote of thanks. Hakim.
Thank you, ma'am. Good evening, everyone. On behalf of the Department of History, Sri Sankaracharya University Sanskrit Faculty, the entire fraternity and the organizing committee, I take this opportunity to thank our speaker, Dr. G Arunima, is professor at the Center for Women's Studies, Jawaharlal Nehru University. It's immense pleasure. Thank you, ma'am, for the insightful lecture on the past and the present of law, reading the legal archive. It was a wonderful experience to be part of this. I would also like to thank all those who actively participated and made it very informative and successful. Thank you all.
Thank you, Arunima.
Thank you.
For the special effort you took in spite of your very hectic schedules. Thank you so much. Really grateful for that. Thank you.
Thanks a lot. I really enjoyed it. Thank you.
Yeah. Thank you, participants. We'll meet tomorrow.